Hi, I'm Eric Terry. I'm a partner here at TorHoerman Law, and I head up the single event team. I'm going to go over a couple of the more common questions I get here as the head of the single event team at TorHoerman Law. One of the most common questions I get asked is, why should I hire TorHoerman Law for my single event litigation? Isn't TorHoerman Law a mass tort firm? We are. It's probably what we're most known for. We've been doing mass tort litigation for over 20 years. However, the same experience and resources that go into our mass tort also go into our single event cases. Our single event clients are just as important as our mass tort clients, and they receive the same amount of attention and resources as every one of our clients. Why do I need a lawyer? Why can't I handle this myself? Simply, the insurance company you're going to be dealing with is not your friend. They're not there to compensate you for your injuries and your losses. They're there to minimize the payout their company makes towards you. What the lawyers at TorHoerman Law are going to do is use our expertise, evaluate your case, and work to get the maximum compensation for you for your injuries. How much is it going to cost me to hire you to handle my car accident? TorHoerman Law operates on a contingency basis, which means that you do not have to front any of the costs or expenses related to your litigation. Our fees are taken as a percentage of whatever settlement or awards you receive for your injuries. That way you can focus on your recovery and we can focus on the litigation. Many potential clients often wonder how involved they're going to have to be in the litigation once it gets going. The truth is, you can be involved as you want to be, but it's our job as your lawyers to handle that end of things. Our office will need to contact you to fill out certain forms, to gather certain information. We may need you to assist us in getting records. And if the litigation becomes formal, we'll need you to sit for a deposition at some point. In addition, we'll have ongoing communication with you to ensure that we're staying up to speed on your personal and medical situations. While some clients will want to be more involved than others, overall, our goal is to make the litigation as low impact on your day-to-day life as possible. Should I expect to go to trial? Well, contrary to what you may see on television or the movies, most cases, including auto accidents, rarely go to trial. Oftentimes, after some initial litigation, the parties will engage in settlement negotiations. We'll always work to settle a case for you if the compensation is appropriate. However, if settlement can't be reached, the lawyers here at TorHoerman Law are fully prepared to take your case to trial. How long do I have to file a lawsuit? In Missouri, you have 5 years to file a lawsuit related to a motor vehicle accident. This is the Missouri statute of limitations related to these types of accidents. Every state has a different statute of limitations. While you may have 5 years under the Missouri statute of limitations, I would highly recommend that you contact a lawyer as soon as possible after your accident. There are a variety of reasons for this, but one of the more important is so that the proper evidence can be gathered before it's lost or misplaced. In addition, while the statute of limitations in Missouri is 5 years, there are some wrinkles that can change that time frame. So I would highly recommend that you contact a St. Louis car accident attorney to go over the facts of your case and ensure that the proper time frames are being monitored. How are settlements determined? This is a very unique, very specific to each case. And clients can receive compensation for both economic and non-economic damages. Economic damages would include such things as medical expenses, future medical expenses, lost wages, and property damage. Non-economic damages would include such things as loss of a normal life, pain and suffering, and disfigurement. What if I may have been partially at fault for the accident? Can I still be compensated? Missouri follows a comparative fault system when determining liability in a motor vehicle accident. This means that you and the defendant may both be assigned fault for the accident. An example of this would be, you could be found to be 20% at fault for the accident, and the defendant could be found to be 80% at fault. Even if you're found at fault under Missouri law, you would still be able to recover compensation. Let's say in a particular case, the court determined that you were to be awarded $100 for your accident. They also found that you were 20% at fault. The court would reduce your award of $100 by $20, and you would be awarded $80. Clients that come to TorHoerman Law often come here after an insurance company denies their claim. Clients then ask me, do I still have any rights? You do. Once you contact an attorney here at TorHoerman Law, we'll analyze your case and determine if in fact the company was wrong and you are indeed entitled to compensation. We may then reopen negotiations and challenge the denial by the insurance company. we may determine the best next step is to file formal litigation and start a lawsuit. What should I do after I'm involved in a motor vehicle accident? The first thing I'm going to do is to ensure that you and the passenger of the vehicle you're traveling in are safe. If you can, move your vehicle off the roadway into a safe position. Next, if you have the ability to do so, you should call 911 and request service of police and, if necessary, medical personnel. If you're able to, in a safe manner, gather information of the other parties involved in the accident. This would include their name, their motor vehicle insurance information, and photos of the accident and license plates if you have those abilities. Lastly, seek out medical attention if you are feeling ill or hurt in any manner whatsoever. If you or a loved one have been injured in a car accident, please contact us at THLawyer.com.